based upon a discernible, if broad, discretionary mandate. In some cases, however, that's simply not the case. In some cases, the FCC simply makes it up out of whole cloth. They make up their mandate, they make up their mission out of whole cloth. The seminal illustration for me is the creation in the 1960s and 1970s of an elaborate regime for regulating cable television. At that time, the FCC had no guidance from Congress. In fact, Congress didn't get into the picture until 1984, by which time the FCC had been regulating cable television for 2 decades. 2 decades with no shred of congressional direction or guidance. How did they get away with that? How did the FCC get away with that? Well, they got away with it by inventing, cleverly inventing, something called ancillary jurisdiction. Ancillary jurisdiction basically looked to Title I of the Act, which gives the FCC broad powers over interstate and foreign commerce and communication by wire or radio, and empowers the FCC to make rules and regulation as may be necessary in the execution of its functions. Now, the first of that is unarguably correct. Cable television is communication by wire or radio within the meaning of Title I. But what about the second part, making rules necessary for the execution of its functions? What are its functions? Well, here's the great irony. The FCC's reliance on that is basically dependent upon finding some other mandate somewhere else in the Act. So what did the FCC do? It basically looked to Title III. Title III is the part of the Act which provides for the regulation of radio stations. Now, the irony here is that Title III was basically was created for the purpose of regulating radio stations because of the perceived spectrum scarcity. Okay? The idea was, well, you can't just allow anybody to use it, you have to license the users. But here's the interesting thing. Cable television doesn't use the radio spectrum the same way. It uses it over shielded conduit. So it doesn't contribute to the spectrum scarcity problem at all. Not only doesn't contribute to it, but in some sense solves it. That is to say, wow, we don't need to regulate spectrum users if we've got a way of delivering television without using the spectrum. So one might have thought, an open-minded regulator might have thought, gee, this is not a problem, this is a solution. Task you were assigned to perform is no longer necessary. Collect your pension and retire to some city. That's not the message the FCC heard. For the Commission, cable wasn't just a solution, wasn't at all a solution to the old scarcity problem. It was a new problem, or more precisely, it was 3 new problems. One, cable television threatened the livelihood of local broadcasters. But that was thought to be bad because the FCC was ideologically invested in local television, locally oriented programming. 2, cable television charged consumers a subscription fee, and that was deemed to be bad because the FCC was ideologically invested in free television, i.e. advertising supported television. 3, cable television at that time retransmitted broadcast programs without paying for the privilege, and that was thought to be bad, even though it was not a violation of copyright laws, because it was considered to be a form of unfair competition. Now, all of these things, they might be bad. We could debate that, I suppose. But for my purposes, it's irrelevant. The FCC wasn't set up to be an anti-bad regulatory agency. It was set up to perform certain specific functions. The question then really is whether or not those functions are implicated by cable television. Well, in the event, the Supreme Court approved the Commission's novel ancillary jurisdiction theory for regulating cable television. However, it in the lower courts later cautioned that it should be understood as not being a grant of general power over anything that can be cataloged as communications by wire or radio, but must be limited to functions that the Commission has been given authority to perform. So one must look to find out what those other functions are outside, presumably outside Title I. The FCC, I think it's fair to say, has not taken that limitation seriously, as is evident from its more recent assertion of jurisdiction to regulate network neutrality in regard to broadband service providers. Network neutrality is one of the most contentious issues in the history of communications regulatory history. The core idea of neutrality is deceptively simple. You simply prohibit broadband providers from discriminating among different content, applications, or services. The trick, of course, is to decide what discrimination means, and that is anything but simple. The FCC has recently proposed a definition of discrimination that goes well beyond conventional legal or economic principles. The FCC's stance on this originally was to sort of take a hands-off position. It adopted some very, very general principles that adjured internet service providers not to discriminate among different content providers, but it did not, contrary to the urging of net neutrality advocates, adopt any specific rules. Then in 2008, a complaint was filed against Comcast for secretly interfering with customers' peer-to-peer exchange of high-volume files, prompted the FCC to take action. Although Comcast settled the case with its complainant, the FCC nevertheless concluded that they had to take jurisdiction and do something about this. It found that the intentional downgrading of traffic by Comcast violated the net neutrality principles, and it then required as remedial action that Comcast disclose all of its network management principles and to file a plan of compliance showing how it intended to abide by the net neutrality principles. Comcast has challenged that in court. It is now lodged in the Court of Appeals as I speak. Right now I'm not taking bets one way or another as to how that will come out. Meanwhile, the shift there's been a little bit of a shift away from the case, Comcast case, to a rulemaking proceeding that the FCC has begun to actually codify the net neutrality principles and extend them in a couple of ways. Both the Comcast case and the more recent rulemaking on saying ancillary jurisdiction theory. But in actually this case, you could make a pretty good argument, I think, that it goes beyond even what the FCC did with cable television. In the case of cable, the Commission was able by some artful means, but able nevertheless, to find a mandate in Title III of the Act to do what it was doing. This time around, there really is no other portion of the statute that is clearly and obviously relevant. The FCC in Comcast rummages around in the statutory flotsam, and those who have read the Communications Act know exactly what I'm talking about. Searching for provisions that might be relevant, and it came up with 7. I'm not going to bother you with them, because you don't want to know. I'm not going to go through all those 7. Suffice it to say, it takes a keen regulatory imagination to find a relevant mandate to any one of them. What of particular interest to me is the one on which the FCC primarily relies, and it is Section 230B of the statute. And here's basically what it says. It'll be the national policy, it is the national policy to promote the continued development of the Internet, preserve the vibrant and competitive free market that presently exists for the Internet, encourage the development of technologies which maximize user control over what information is received by individuals. If you're thinking that's pretty atmospheric, Yeah, it is. It's pretty atmospheric. And standing by itself, you'd be kind of hard pressed to think of that as a mandate for doing something. Doing what exactly? Indeed, the absence of a mandate is further corroborated by another section of that very provision, which articulates this policy objective. I quote, "To preserve the vibrant and free market that presently exists for the Internet and other interactive computer services unfettered by federal and state regulation." Oops. Well, let's forget about that part. Well, admittedly, part of it, the FCC's response to that may be mindful of that. The FCC, in its recent rulemaking notice, says that its proposals are not, quote, intended to regulate the Internet itself. What exactly is the Internet itself? FCC seems to regard the Internet itself as some kind of disembodied essence that floats independent of the physical infrastructure or the physical networks that support it. It sort of reminds me of the part in Alice in Wonderland where Alice is confronting the Cheshire Cat, and the Cheshire Cat keeps making appearances and reappearances, and she gets kind of flustered. And so the cat finally disappears altogether, beginning from the tail forward until there's nothing but a grin behind. Said Alice, "Well, I've often seen a cat without a grin, but a grin without a cat, it's the most curious thing I ever saw in my life." But Alice had never encountered the FCC. What the FCC is doing here basically is taking advantage of a general public vagueness about what the Internet is in order to define it to fit its regulatory objectives. The Internet becomes, in essence, what defines the essence of a Cheshire Cat, which is its grin. Never mind the bottom. What's distinctive about the Cheshire Cat is its grin. There obviously, apart from that confusion of definition, there may be a little bit of cognitive dissonance here as well, which is to say that the Congress has said, and the FCC itself has said in other contexts, the Internet should not be regulated. Therefore, the FCC tells itself what we propose to regulate cannot be the Internet. Can't fault that logic. The most obvious lesson suggested by story number 2 is that the cliche about federal administrative agencies being arms of Congress is, to put it bluntly, something of a howler. An agency that can invent its own jurisdiction and its own mandate is not an arm of anybody. It better fits the description that poet James Russell Lowell made of the Constitution in 1988. It's a machine that would go of itself. As with the Constitution, so with the FCC, you wind it up, let it go. Actually, that's not right. You don't wind it up, it winds itself up. That's the point. It's long been debated whether there should be any constitutional constraint on the delegation of broad powers to administrative agencies. It is today a purely academic debate because the Supreme Court's made it abundantly clear over and over again that there is no constitutional constraint on such delegations. Fine. Still, the absence of any constitutional constraint doesn't determine the statutory question of statutory interpretation. One might think that going about interpreting statutes, there is still the question of does the statute fairly create this kind of jurisdiction and mandate, regardless of what Congress could do. Did they, in fact, do it? Now, if the concept of ancillary jurisdiction were simply a statutory interpretation heuristic, a kind of like a canon, if you will, it would probably be unobjectionable, but it probably wouldn't do any real work. Because the way in which the FCC has used this concept, it really depends upon a concept of living legislation in which the statutory purpose is fluid and adaptable and meaningful legislative directions are simply irrelevant. It's again like creating a common law court, I guess.